interim between today's date and the July in Banc, and further certifying that IALTA accounts have closed and will not control client funds moving forward. Is there anything else the board needs to address at this time, Mr. Daniel?
No, Your Honor.
And anything else, Mr. Marine?
No, sir. Thank you, sir.
Then this matter is now resolved. We'll see you in July. Thank you both, and you may be excused.
Thank you.
Thank you, Your Honor.
And Ms. Truitt will call the Rios case.
Should I let the witnesses in as well, or not quite yet?
Why don't we wait, since I don't think the commission's going to present them yet, and that way it's better to keep them under the rule at this point.
Okay.
We'll call cause number 64719 in re Ramon Rios. The record will reflect that non-participants and witnesses are in the waiting room, and only the parties and counsel are within the Zoom. If counsel would please state their appearances for the record.
Judith DeBerry for the Commission for Lawyer Discipline.
Steve Lee for, his legal name is Ramon Gerard Rios. We all know him as Jerry Rios.
Thank you. Does either side wish to make a brief opening statement?
Yes.
I'm just ready to put on the case. I don't know if you want a separate opening statement.
Well, at that point, typically the respondent's opening statement is contingent upon whether you're going to give one first. So if you're not having an opening, then I think he has to present his at the beginning of his case. So I leave it to you.
Okay. May it please the board then. This is a compulsory disciplinary case based on respondent's conviction for misapplication of fiduciary property, a second-degree felony in the 450th Judicial District of Travis County, Texas. We filed our petition for compulsory discipline on September the 9th, 2020. Respondent was personally petitioned and notice of hearing on September the 11th, 2020 by George Castillo, a private process server. Proof of service has been on file since October the 9th of 2020. On July the 29th, 2014, respondent charged by indictment, where on September the 20th, 2006 through February 2009, he intentionally, knowingly, or recklessly misapplied property, to wit, currency in the value of more than $100,000, $200,000. As a fiduciary, person acting in a fiduciary capacity, but not as a commercial bailee, contrary to an agreement under which the respondent held the property, and in a manner that involved substantial risk of loss of said property to Ronald Park, Raul Capitan, and I hope I'm saying that correctly, and Capro Investments, the owner of said property, and the persons for whose benefit the property was held, by diverting company money to himself in cause number D-1-DC-14-900-131, styled the State of Texas versus Ramon Gerardo Rios in the 147th Judicial District Court of Travis County, Texas. On August the 4th, 2017, respondent was charged by amended indictment in which he was again charged with misapplication of fiduciary property and containing identical charges as the original indictment, with the exception that the dates of the crime alleged were from September the 20th, 2006 through April the 30th of 2008 in the same number. On August the 4th, 2017, a plea of guilty, admonishments, voluntary statements, waivers, and stipulation in judicial confession was entered, and wherein the respondent pled guilty applications of fiduciary property assessment in cause number D-1-DC-14-900-131, State of Texas versus Ramon Gerardo Rios. On September the 15th, 2017, conditions of community supervision were filed in the underlying case wherein respondent was placed on community supervision for 10 years, ordered to pay restitution in the amount of $177,800, complete 100 hours of community service, and receive counseling treatment designated by the supervision officer, have no contact with Ron Park or Raul Capitan, ordered not to obtain employment in real estate, and have no contact with Capro Investments LLC. On September the 22nd, 2017, an order of the court deferring further proceedings was filed in the underlying case, wherein the conditions of supervision were the same as in the September 15th, 2017 conditions of community supervision. At this time, I'd offer the following exhibits. Exhibit number 1 is a certified copy of the indictment in cause number D-1-DC-14-9000131. Exhibit number 2 is a certified copy of the amended indictment in the underlying criminal case. Exhibit 3 is a certified copy of plea of guilty, admonishments, voluntary statements, waivers, stipulations, and judicial confession in the underlying criminal case. Exhibit 4 is a certified copy of the conditions of community service. Exhibit number 5 is a certified copy of the court deferring further proceedings in the underlying criminal case. Exhibit 6 is my original affidavit attesting to the fact that the respondent is the same person as the person identified as the defendant in the criminal case. Exhibit 7 is the original certificate of Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated January the 11th, 2021, indicating the respondent is licensed and currently authorized to practice law in Texas. And Exhibit 8 is a copy of the respondent's prior disciplinary judgment from 2013. At this time, I would offer Exhibits 1 through 8.
I don't have,
I believe respondent has no objection, however, would point out that Exhibit 1 was superseded by Exhibit 2.
all right, I don't have 7 and 8 in the materials. I'm looking through right now, and it may be that it's just my copy that's bad, but barring no objections to Exhibits 1 through 8 with the notation as provided by counsel, those are admitted.
And we respectfully seek an entry of judgment of disbarment. Thank you.
Mr. Lee.
Has the State Bar rested?
I believe they have.
Okay. May it please this honorable tribunal. My name is Steve Lee, and I'm representing Ramon Gerardo Rios. He's known in the practice as Jerry Rios, and that's probably how you'll hear him referred to throughout. Mr. Rios was licensed to practice law on May 2nd, 2008. On August 4th, 2017, Mr. Rios accepted responsibility. He entered a plea to conduct that occurred between September of 2006 and April of 2008. The trial court deferred any adjudication of guilt, and on September 15th, 2017, placed Mr. Rios on community supervision for a term of 10 years. That's a sentence to run from September 15th of 2017 until September 14th, 2027. The evidence will show Mr. Rios is currently on probation and is in compliance with all of the terms of his probation. Mr. Rios is on probation for conduct that occurred before he was licensed to practice law and occurred outside of the practice of law. Mr. Rios' conduct occurred while he was acting as a mortgage broker. The facts and evidence will also show that at the time the plea was entered, it was the belief and understanding of both Mr. Rios and the prosecuting authorities, and apparently the judge, that this being placed on community supervision for this matter would not prevent Mr. Rios from practicing law. Mr. Rios is a person who's serving a fully probated sentence, and therefore he comes before this honorable tribunal seeking to have his license to practice law suspended during the term of his probation, pursuant to Rule 8.06 of the Texas Rules of Disciplinary Procedure. Mr. Rios requests that this honorable tribunal exercise its discretion granted to it by Part 8 of the Rules of Disciplinary Procedure and affirmed by the Texas Supreme Court in the 2008 case In Re Caballero, and suspend his license to practice law while he's on probation. Mr. Rios will present evidence in support of his request that State Bar's plea for his disbarment be denied and that his plea to have his license suspended instead be granted. Thank you.
Thank you, Mr. Lee. You may call your first witness.
I would call Jerry Rios.
Mr. Rios, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Good morning, Mr. Rios. For these proceedings, would you please state your name for the record?
Sure. It's Ramon Gerardo Rios.
Sorry for mispronouncing your middle name, Jerry.
No problem.
A little bit about your background. Where are you from, Mr. Rios?
Born and raised in Corpus Christi, Texas,
What year were you born?
1976.
You attended college?
I did. University of Texas at Austin.
And what year did you graduate?
1998.
And you're a law school graduate also?
Yes, I am. I went to St. Mary's University in San Antonio and graduated in 2007.
From that, I would gather you did not go straight from college to law school. Is that correct?
No, I had a little bit of a break and worked before going to law school.
What were your intentions when you graduated from college? Were you planning to go to law school?
You know, at that time, no. I guess so. In 1998, I graduated. I guess it would have been May, late May. My intention was to take a couple of months off and then head up to Dallas. And at that time, the goal was to enter graduate school and try to obtain an MBA.
What stopped you from going to Dallas and obtaining an MBA?
Well, I guess it would have been about September of 1998. My grandfather down in Corpus Christi had a heart attack, and he owned a restaurant. It's a Mexican food restaurant called Rios Mexican Food. And he had owned that my whole life, I think since 1977. And he needed some help. And while I was in college, I worked at different restaurants in the Austin area as either a bartender or server, had done some managing. And I had, I guess, really no set plans at that time. And so when he needed help, I told him I could go down there and help him for as long as he needed. I went down there in October of 1998 and began to help him manage the restaurant, the existing restaurant, and did so for about 2 years, maybe 3 years. We opened up a second restaurant during that time period. And, you know, I guess it would have been mid 2000, early 2001. He decided he wanted to retire at that point, sold the restaurants, and I needed to find something else to do at that time.
What did you find to do at that time?
I went into the mortgage business. I had a customer of the restaurant that was a mortgage broker, and talked to him, and really thought a lot of the profession, you know, doing residential home loans, doing commercial loans, which is really what I wanted to do. So I obtained the license, the initial license, mortgage brokerage license, which is like a mortgage salesperson. And I worked for a company out of Austin. I guess it would have been 2001 through 2005. Did residential loans. I did SBA loans, commercial loans, hard money loans, and basically acted as a lender. That was my career path at that time, and all the way up through about 2003.
Now, to get back toward the matter we're here for, was it hard money lending that led to the prosecution in Travis County?
That's correct.
Please describe for these folks what hard money lending is.
Sure. So hard money lending is lending, in our situation on real estate. The asset is real estate. And so what happened was we have a borrower that needed to
And who's we?
borrow money either to purchase or refinance real estate. That person typically didn't have the credit history or credit score or the funds for a down payment, or a combination of all three of those things. And so there are lenders out there, such as Capro, that will lend based on the value of the asset itself. They'll lend you 60 to 65% of the asset, regardless of who the borrower is. And so that's what hard money lending is, kind of in a nutshell.
Yeah, you mentioned Capro, and Ms. DeBerry mentioned Capro being in some of the Travis County proceedings. Who is Capro?
Sure. So Capro is an LLC that was formed by Ron Park, who's an accountant down in Corpus Christi, and then Raul Capitain, who is a doctor in Corpus Christi. Capro was formed, I want to say, around 2004. I met Ron Park in 2003. We started doing hard money loans using his own capital. He brought in Raul Capitain, who was a doctor that wanted to invest in these loans that Ron was doing. I want to say that was the time, 2004. And so there was a new pool of funds that was available. So Capro is basically just a partnership between those two people that had maybe $3 million to lend. And so what I would do is I would go out and find borrowers for them and write up loans and basically make short-term 1 to 2 year loans using their capital at a 12 to 15% interest rate.
So these are sort of high interest rate loans for people who weren't eligible for traditional financing.
Exactly. Short-term loans, 1 year, 2 years max.
And is there more risk in these kind of loans than in traditional financing?
Yes, when it comes to the borrowers, if you're dealing with somebody that doesn't have the 20% minimum down payment, there's a risk there. If they don't have a credit score, or at that time, loans were being made based on what was called stated income. Somebody would just say, I make this much money. I think most people have heard of those types of loans at this point. So that was all prior to the market crash of 2007. So yeah, there was some risk there. I think they would, the risk was alleviated somewhat by ensuring that the loan amount never exceeded 70% of the actual value of the asset.
Now, looking at the amended indictment, Exhibit 2, it appeared that the conduct that you were charged with occurred while you were in law school. Is that correct?
That's correct.
How did you end up deciding to go to law school, and when did you enter?
Well, when I was working as a mortgage broker, one of the things that I noticed was that a lawyer was required for every transaction that we did. It's typically somebody at a title company or a lawyer that owned a title company. We did loans all over the state, primarily in Central to South Texas. And I thought that was something that I could do. And so I had a couple of friends that had gone to law school. I talked to them about that. That would have been 2002, somewhere around that time. And I decided to try it. And I took the test, took the LSAT, and decided I wanted to try to go to law school. And it was something that was going to require some changes because we lived in Corpus Christi. There's no law school down there. So I applied to St. Mary's and I applied to UT. And I got into law school. I passed the LSAT with a high enough score, applied, and I decided to go to St. Mary's. And so I started St. Mary's. I was supposed to start actually in 2003. My first daughter was born. She was supposed to be born in December of 2003. She wasn't born until January of 2004. And during that pregnancy, I decided to wait a year, and I actually entered law school in 2004.
Okay. Are you currently married?
Yes.
And Do you have any other children besides that daughter?
Yes. So that daughter is now 17 years old. I have a son from that marriage who's 13. And then I have a stepson who is my wife's from her previous marriage, and he is 31 years old.
Okay. So you completed law school and obtained your license in May of 2008. Is that correct?
Yes, sir.
Okay. Uh, Are you licensed or admitted in any other states or any other jurisdictions or before any governmental agencies that require admission to practice?
I've obtained admission in one federal court in Colorado because of a case that I needed to work on there. And then as well as one of the northern districts in Illinois that covers the Chicago area based on a federal case that I worked up there. Those were all pro hoc vice. So other than Texas, I'm not admitted in a state, but I do have those admissions.
Now, Ms. DeBerry has recounted your service with this compulsory petition. We needed a continuance, and as a part of that, you agreed to the entry of an interlocutory order of suspension. Do you recall that?
I do. That's correct.
You remember the effective date of that suspension?
October 30th of 2020.
And you were able to wind down your practice and comply with the terms of that, surrender your license and bar card, et cetera?
I was, and I did. Yes, sir.
Okay. Now, between the time you were first admitted and the time you surrendered your license under that agreed order, what kind of law did you practice?
I've always done work with small business owners. I started out with just some advising, legal advising on contracts. I then, within the first year of practice, was doing litigation, again, for things like contracts, partnership disputes, really anything involving a company or real estate.
Okay. Now, according to Ms. DeBerry, and we don't contest it, the conduct for which you were charged in Travis County was between September of 2006 and April of 2008. But I don't believe you were charged until 2014, some many years after the last act. And ultimately, a plea was not entered until 2017. So you practiced law for about 11 years. Is that correct? Am I right? Nine. Let's go through the facts. Yes. Pardon me?
To that point, yes, that's about 9 years. It's a total of about 12 years, 12 and a half years.
Now let's discuss the facts that
suspension.
ultimately led to your entry of a guilty plea in that case. You had a mortgage broker's license, correct?
Correct.
And you were attending St. Mary's Law School, is that correct?
Yes, I started attending in 2004.
Well, explain the dealings with Mr. Park and Dr. Capitan that, well, what was the chronology? You were making these loans. Let's just jump ahead. While you were in law school, did you also become a borrower of Capro?
Yes.
Capro? How much did you borrow from Capro?
It depends. So the transaction started in 2003. I think I made my first loan with Capro in 2004, and that was for a used truck that I was buying. So there was, $10,000 there. It wasn't a huge loan. And then I borrowed, I want to say it was $80,000 to purchase a rental property in Corpus Christi. And I'll add these up in a second. I just got to kind of go through them in my head. But I borrowed, along with a family member, an additional $30,000 to purchase and rehab a rental property. And then I borrowed probably an additional $90,000 to $100,000 for just personal use. It was unsecured, but at a high interest rate. And so that final loan was made, I want to say late 2006, early 2007. And then I stopped working with Capro in about 2008, late 2008.
Now, you earlier mentioned 2007 as the crash. My recollection is it was around August, September, October of 2008 that we had what's since become known as the Great Recession. Is that what you're referring to? And
That's correct.
would you agree with me that was largely fueled by the collapse of the securitized lending market?
Yeah, and so the way I remember it, prior to the collapse that we all know about, the lenders, the underlying lenders that I work with, started pulling back their products that were available. So it started out with loans in California that we were able to do as a mortgage banker that you could do for 125% of their value, which still seems ridiculous, but that was a loan that was available. Those went away very quickly in early 2007. And then the stated income or no income, no asset loans went away. And then, just kind of like dominoes, all of the loans that were available to take out a loan, such as a hard money loan, dried up. And so I would say my recollection is late 2007, early 2008. So I don't remember what the actual date was of the crash, Bear Stearns and all that stuff, but I think your timeline is about right.
How did this contraction of the lending market affect your relationship with Capro?
Well, so the problem was that at the end of 2007, when I graduated from law school, I was still primarily in the mortgage market. I hadn't taken the bar yet. And so my income started to dwindle. And so my ability to repay the loans that I had with Capro, it just became very difficult. And as time progressed, was almost impossible. And so we get to, I guess it would be the first time I took the bar exam, which was, I want to say July of 2007. And I was working. I needed to work. And so any deal that I could do, and these were non-Capro deals. I had other loans that I did. Capro was a part of that, a small part of that. These other loans took up my time. I needed to earn money. And so I didn't study for the bar exam. And I just missed passing it the first time I took it. So basically waited. You get the results a few months afterwards, and I set up to take the next one, took the Barbie course, and I passed that. And so I started practicing, I would say, beginning of June of 2008. And of course, during that time, when you're starting a law practice, nothing is a given. And so my income was low. Capro was working with me. Ron and Dr. Capitan were working with me to defer the payments. I made several payments. I made what I could to the tune of maybe $12,000 to $15,000 over that 1 year period. But I was still behind. And so my relationship was really with Ron Park. I've only met Raul Capitan one time, but the relationship wasn't good. And before then, it had been great. I mean, we were good friends. He was a friend of my father's. They were both accountants. I would travel to Corpus Christi while I was in law school once a week to go meet with Ron. We'd have lunch. I remember my dad telling me, you eat lunch and meet with Ron more than you meet with me, that kind of thing. So the relationship wasn't good. And because I couldn't pay the loan on time back in 2008.
What resulted from your inability to pay the loan?
Well, immediately nothing. Phone calls and we talked, that kind of thing. But in 2010, I was sued. They sued me in Nueces County in district court for repayment of the loans.
Now, let me ask, were you sued solely for repayment of loans?
No, well, they sued me. They sued my law firm that I had just created at the time. It was a professional corporation. And they sued the company that I owned that provided the loans, which was called Blue Wave Capital. And they sued me for the breach of contract. They sued me for negligence. They sued me for fraud, basically anything that you could sue for. And it was the same statement, basically, but just different legal theories.
Well, but was it solely for the fact you did not pay loans, or did they find fault or allege fault with your conduct of the mortgage business in relation to them?
Sure. Well, so it was for the loans primarily. The second part of that would be the negligence part. And so the negligence was they felt that I had put them into, or put the company, excuse me, put the company into loans that were too risky. And so my understanding was that they were having trouble collecting payments on the loans after I had separated from Capro and helping them. That was the other part of my job. In addition to making the loans, I had to help them service the loans, which just means collecting payments on a month-to-month basis. And so my understanding was they were having trouble when they were going to foreclose. Sometimes the properties were no longer worth 60 to 70% of the value they were worth, the loan value, or maybe there was some that were slightly upside down. And so, they had some issues with the property in 2008, 2009, somewhere in that time frame.
Do they also have issues with your remittance of funds collected?
That was one of the allegations. That was one of the issues. They said that when I obtained funds, instead of tendering the funds to them and getting paid back, they said that the practice that we really had the entire time of tendering a net amount of funds was negligence and was a misrepresentation. And so, that was the other.
What do you mean by a net amount of funds?
So in other words, if we went and we did a loan of $50,000, let's say 100,000. 100,000 is about an average loan amount for these types of deals. And so if there's a loan amount of $100,000 and there are title fees, that may be $1,500. There may be deeds that are drawn up, deeds of trust, et cetera. The lawyer's fee on that might be $400 to $500. And then there was a percentage. And so if I charge, for example, in that case of 100,000, if I charge 2%, then I would make $2,000 on that loan. That's the brokerage fee. Now, in that case, $100,000 would be loaned. And I would say that, we would take the fees out of whatever we loaned and then give the borrower the money or pay off whatever needed to be paid, depending on the transaction. And so the same thing was true whenever there was money that was coming through, that somebody would make a payment. And if there was money owed to me, what I would do is I would say, well, you guys still owe me $2,000 from a transaction or whatever it was. And so instead of remitting $5,000, I would remit $3,000. So that's what I mean by net funds.
And this was a custom that had developed between you and Mr. Park?
That's correct.
And did you account to him for any money you withheld?
There was a spreadsheet that we had from the beginning. And so we basically did a spreadsheet. There was two. There was one for loans that were done using Ron's personal money. And then there was a second spreadsheet that was used for Capro loans, or loans done with Capro money.
How was that civil suit against you, your law firm, and your mortgage company resolved?
Well, so it progressed. There was, a couple of years that it was pending. It ultimately was set for trial. I represented myself during the pendency of that loan, or of that litigation. And when it got down to go to trial, we tried to mediate. We tried to come up with an amount prior, like 3 days prior to trial in Corpus Christi, and we could not agree to an amount. I was offering to pay what I believe I owed on the loan, or the
about how much
balance, which was about 155, somewhere around there. That included interest, things of that nature. And they were, what they wanted was a repayment of the loan. And I get that. And I completely understand that. But what they wanted me to sign was a settlement agreement for $600,000. And I just couldn't do it. I wouldn't do it. I looked at hiring an attorney at that time to help me with the trial. I couldn't find one. And what I got back from one of the attorneys down in Corpus was just file bankruptcy. And so that's what I ended up doing. So right before the trial, I filed personal bankruptcy, and that's how that matter was resolved.
Was their settlement figure an attempt to recoup any losses from bad loans that you wrote and recoup some of the fees that have been paid to you in addition to collecting your loans?
No, I don't think it was that way. I think from what I understood, talking to the attorney at the time, what they wanted was some kind of a high bar for me to not pay these monthly amounts. And so the discussion was something like, okay, you're offering to pay 150. We want you to pay more than that. And of course they added attorney's fees to that. That was fine. And so the amount was somewhere around 600,000, and it was an agreed judgment is what they were proposing. You give us an agreed judgment, you come through, you make your monthly payment. The payment was somewhere around $4,500 a month. And I just didn't think I could make that payment. And I said, I can't do it for that amount. That doesn't make sense. I was earning maybe $5,000 or $6,000 a month at that point. So it was destined to fail. And so the idea was that would be enough of an incentive for me to make a payment, to know that if I defaulted on the loan, I had some high amount, that was sitting there as a judgment against me.
The bankruptcy, you did declare bankruptcy?
I did.
Did that bankruptcy also include your then law firm and the Blue Wave Capital?
I don't think I filed a separate bankruptcy for that, for the companies, but they were included because the only owner of those companies was me.
Okay.
And so I remember that the companies were ordered to close by the court.
So did your filing of bankruptcy stay the Nueces County litigation?
It did. It did.
And then was proper notice of your bankruptcy given to all creditors, including Ron Park, Dr. Capitaine, and Capro Investments?
It did. Yeah. Yeah, absolutely.
Did they contest your discharge?
I got a call from their attorney the day that I filed, or the day after that I filed the lawsuit, and I told him I couldn't talk to him. And he understood. But he said that we got the notice, and he was upset about it. But no, they never filed anything in court. So I went through the process, had the 341 meeting for creditors. Nobody showed up. Went through the process of the time. I think it was about a 3-month period to get the discharge, and there were no objections, and the debts were all discharged.
So despite the fact you've been sued for fraud, they didn't try to exempt that lawsuit from discharge?
That's correct.
All right, so you get discharged in bankruptcy. Does that then terminates that alleged indebtedness to Capro, Capitaine, and Park? Is that correct?
That's correct. That would have been, I believe, early 2013.
When did you have your next legal problem based upon your prior dealings with Capro?
So approximately a year later, I received a call from the Lakeway Police Department, and they asked me to come in, and they wouldn't tell me what it was for, but I lived in Lakeway, and which is on the west side of Travis County. And I went in and I talked to an investigator, and she told me that I was being investigated for almost exactly what was alleged in the civil suit. And so we talked. I want to say that was about maybe 2.5 hours at the most. And then a few months after that, I got a call from her again. Her name was Mary. I forget her last name. But she told me that an indictment had been filed and there was a warrant for my arrest. And I was actually working at the time. I had a hearing the next day, and I told her that I would turn myself in if that would be okay. And so I did. And I turned myself in, walked through, and that's when all the criminal matter, the issues in the criminal case started, to my recollection.
Prior to your indictment, were you represented by counsel?
No.
After the indictment, did you obtain counsel?
I obtained counsel to help me, to get me out of jail, number one. That was a friend of mine that does criminal law. And then I obtained Steve Toland as my counsel probably a month after I did my walkthrough.
By my calculation, it was approximately almost exactly 3 years between the time of indictment and the time of entry of plea in your case. Is my calculation correct?
That sounds about right. It was a long time.
Can you give the Board of Disciplinary Appeals a broad overview of what happened between indictment and the time you gave serious consideration into entering into a plea?
Sure. For the first, I want to say 16 or 18 months, nothing happened. I'm really still not familiar with the criminal court other than my own case. And so what happened during that time is there would be a setting. I would have to go down to the courthouse. I'd have to check in with the bailiff. Typically Steve or one of his associates would be there, and the case would be passed to the next month. And so there was no communication that I knew of other than what Steve would tell me was being talked about behind the scenes. And so we did that, like I said, for 16 months, so maybe 15 times. From what I understand, during that time frame, the ADA or the assistant district attorney in charge of my case changed many times. And so we had one person that was dealing with the case, and then they would go off somewhere else. Somebody else would come on. They'd have to get caught up to speed on the case. And so nothing happened for the longest time. And then all of a sudden, a year and a half or more into the case, things started moving a little bit. And we had, some conversations back and forth. And there was one time where Steve and I went and we talked to the ADA at the time and learned about what they had and what they could do with the information. And so that's when Steve and I started talking about options. And so one of the options would be a plea deal.
Well, what was your analysis of the pros and cons of accepting a plea? What were the factors involved?
I mean, at first I didn't want to do that. I mean, I was ready to go to trial. I told Steve that's what I wanted to do. He told me that based on the allegations,
I'm going to object to hearsay on what Mr. Toland told Mr. Rios.
I'm going to overrule it. You can go ahead and answer.
Okay. So Steve explained what the different levels of guilt were, basically the intentional, the knowing, and the reckless. And so what I understood at the time was that, intentional was something that probably wasn't something I had to worry about, but reckless was an issue. And so looking at the way the transactions were done, it was, I don't know, I forget if you mentioned it or if opposing counsel mentioned it, but, there has to be some agreement between the parties. And the problem that we had was when it came to handling money and how remittances were handled, there was really nothing in writing. And it was all, just something that we did as a matter of course. And, if I had class and I couldn't get to the bank, because the bank that I deposited checks to at that time was in Corpus Christi, I had to actually go there. Then we wait till the next week, that kind of thing. So what I understood is that I was a fiduciary. And so as a fiduciary, being reckless is not a high bar. And so there was a chance that I could be convicted for that. And that wasn't a chance I wanted to take.
What were there any other factors in deciding to accept? Let me put it this way. Had you concluded there was a reasonable probability that the state can make the standard that your handling of remittances and your retaining of funds you felt were owed to you, absent a proper writing, subjected you to a finding of reckless misapplication of fiduciary property?
I think I know what you're asking, but it was breaking up. Could you ask it again? I'm sorry.
What I understood you were saying, and I'm trying to see if this is correct, was that particularly in handling remittances, by turning in a net amount and reporting without written authorization to do that, you felt subjected you to a reasonable probability of being found guilty of reckless misapplication of fiduciary property. Is that correct?
That's correct. Yes, sir.
Okay. Now, did you appreciate at that time that as a lawyer, well, first of all, did you know more about fiduciary duties as a lawyer than you did when you were a college graduate mortgage broker?
Absolutely.
Did that factor into your consideration of your chances if you did take the case to trial?
Yeah, that was the biggest factor. Yeah, that understanding how the relationship would be viewed and what the requirements were under the law. Absolutely.
And did you understand that if you went to trial, you would be identified as a lawyer, despite the fact that the conduct occurred when you were not a lawyer?
You cut off at identified. I'm sorry. I don't know. I can't hear you.
Did you realize you would be identified as a lawyer, as a defendant, if you went to trial? Can everybody else hear me?
I'm showing that
Mr.
Mr.
Rios.
Rios is frozen.
Yes, he looks frozen. I was trying to figure out if it was my connection or his.
Let's go off the record for a second and see if I think his connection has dropped.
May I have permission to text him? And oh, did he go away? He's probably trying to log back on.
Absolutely, you can certainly text him.
I don't know if he has his phone on now that I think about it.
It's okay, it happens.
Okay, he will. Yes, he says I'm trying.
Can you all hear me?
We can.
Okay. I'm sorry about that. I'm not sure what happened there.
Ms. Seibert, can you hear? All right.
I was simply asking if you had any concern that going to trial as a licensed attorney accused of misapplication of fiduciary property might influence the trier of fact.
Absolutely.
And
yeah.
And let's just jump to the punchline of this. Did you believe or understand that entering a plea was going to result in compulsory discipline, suspending, or disbarring you?
No, not at all. That's one of the things that took so long to arrive at a plea. And Steve can talk to you about this a little bit in more detail than I can remember. But my understanding was that that he had talked to somebody at the bar, and that the judge was aware of, what my concerns were. And that was really my concern. I wanted to continue to practice and be able to earn a living. I had no issue with repaying money that I thought that I owed, as long as it was what I owed and not double or triple that amount. So yeah, my understanding was that I could continue to practice, and I had no indication that compulsory discipline would have been an option or mandatory at that time.
Now, when you say you believed that you'd be allowed to continue practice, did you do any independent investigation of that yourself?
I didn't. I did not.
Who did you rely upon to form that belief?
My counsel.
Okay. And knowing what you know today, do you harbor any ill will toward Mr. Toland for his advice?
No. I don't know what happened. I don't know if it was a mistake. I don't know if it was, somebody said something they shouldn't have said. I really don't know. I think Steve did a great job. He did the best job that he could with the circumstances. I consider him a friend. And so if this is one of the consequences, then it's what, it's what has to happen. And, again, it's been hard. I'm not going to say it hasn't been hard. I don't have any ill will against Steve. I have regrets, obviously. But based on what I know and what I knew at the time, I thought that was the best course of action to take that would allow me to pay back what was owed and continuing to earn a living to do that.
Well, in hindsight, have you reconsidered? I mean, do you believe if you'd gone to trial, you might have obtained a favorable outcome?
No, I think the fact that the actions that I took were reckless and could be deemed reckless by a jury or judge, I think the outcome would have been the same.
Or possibly worse?
Possibly, yeah. I guess anything's possible.
But you don't practice criminal law, do you?
No.
So you wouldn't appreciate whether a person who goes to trial ends up with a worse sentencing position than someone who enters a plea?
I mean, I know that it happens. So yeah, that's what I'm saying. It's possible. So.
And do you harbor any ill will toward the prosecutor for accepting this case and presenting it?
No. Prosecutors doing their job. I haven't even thought about that, to be honest with you.
Well, since you surrendered your law license in October, what have you been doing to support yourself and your family?
A couple of things. So about 2 years ago, I started a couple of construction companies. A lot of the clients that I work with are contractors. Most of my clients are owner operators, so they are self-employed for all intents and purposes. And so I started a steel fabrication and welding company. We do jobs of all sizes, mostly commercial jobs. That company is called Tarpon. And then I started a plumbing company, and that plumbing company does commercial and residential construction. And so what I've done for the past almost 6 months is basically work more hands-on than I had in the past. I've also started doing some mediation. I got certified as a mediator. I had been doing some mediations, but I thought the certification was important. So I do mediate civil cases, business cases, basically real estate cases, but not a whole lot. I'm still trying to build that practice up. And that's really it at the time.
Have you been able to replace your income that you were enjoying as a lawyer with the income from these non-law businesses?
Not completely. Like I said, it's been hard. I'm probably at somewhere under 50% of what I was earning before.
Well, now that you're forbidden from practicing law, how do you feel about the practice of law?
How do I feel about the practice? I wish I was still practicing. I miss it. It's a little surreal because almost from day one, I realized how much my own identity is wrapped up into being a lawyer, and my interactions with people and what they expect from me, and it's hard on a lot of different levels. I mean, there's really no getting around it. It's one of those things that it feels like your identity is stripped from you overnight, and so I've had to tell people that I'm not a lawyer, that I'm not practicing, that I'm suspended. I tell people that I'm a mediator and I mediate cases, and I want to help them. I think a lot of people have been disappointed that I haven't been able to help them when I have to tell them, I can give you some phone numbers for some attorneys that I think are good attorneys that can help you. But I can't, and it's disappointing on a lot of different levels is what I would say.
Would you agree that you and I looked at whether there was any probability that asserting that the conduct that led to your conviction while you were an attorney occurred when you were not an attorney did not appear to provide any exception to the compulsory discipline rules?
I agree.
So have you accepted that the outcome of this hearing is not going to restore you to the practice of law immediately? You're either going to be disbarred, or if your plea to this tribunal is accepted, your suspension will continue during the term of your probation. Is that correct?
That's correct, and I understand that.
You said, you indicated you have no hostility toward Mr. Toland or no hostility toward the prosecutor. Are you upset with the bar that either that the rules have never been construed to give you a safe zone for this conduct that occurred outside the practice, or that the bar has brought this case, even though it seems to be contrary to the intentions of the court and the prosecutor and your own when you entered the plea?
I'm not upset with the bar at all. Again, if this is what the bar does, it's part of their job, and I completely understand and I get that.
Do you want to return to the practice of law in the future?
Absolutely. That's why I'm here.
Before I pass you to Ms. DeBerry, do you have any additional comments? Is there anything I didn't ask you about that you would like for this tribunal to know about you or your practice? Anything that will assist them in making decisions as to whether to grant your plea?
I would hope that the panel would consider this suspension as an option and grant the suspension, because I do want the opportunity to come back. This is what I know. This is what I do. I realize that the next few years are going to have to be different, but I want to have that goal, and I want to have that ability to come back and restore my name and what I've done in the past, and just be able to take the role back on that I had, which was helping people through their problems. And I realize that, it's a small niche, working with business owners, but that's what I love to do. And that's what I've always done. And that's what I hope to continue to do. And if it takes 7 years, and I understand that, and I realize that that's part of the consequences.
Thank you, Mr. Rios. I'll pass the witness.
Thank you.
Ms. DeBerry?
Okay, I just have a couple of questions, Mr. Rios. Originally, the conditions of probation were for 300 hours of community service, and I think that was changed to 100 hours. Can you tell us why that was changed?
I don't remember. I'm sorry.
I said, if you know.
I don't know the reason. I remember standing there when the clerk wrote 300 and then drew through it and said, "Oh, we agreed to 100." That was a mistake.
Okay. And when did you complete that community service?
Within 6 or 7 months of signing the plea deal.
Okay. Where did you complete your community service?
I did it at I don't remember the name of the state office, but there's a state office over off of Shoal Creek near 45th Street that does books on tape for hearing impaired people. And that was one of the options that I had. And that,
okay.
I'm sorry. And
Books
that was
for the blind or whatever it is.
That sounds right. And I have some people in my life that are visually impaired. I'm sorry, I said hearing impaired, visually impaired. And I just thought that would be a good use of my time.
Okay. And I believe you stated you were current with your restitution payments.
I'm current. It's been tough to make those payments, to put it that way. But yeah,
Did you make the March payment?
I have a modified payment plan right now, but yes, I have made the March payment. I made a payment in April.
How was it modified?
My probation officer allowed me to skip a couple of months, and so that's where I'm at. And that started about a year ago. After COVID started, my practice slowed down a little bit, and then of course when this happened, it slowed down to nothing.
So how many of those payments have you skipped?
I think I've skipped full payments, maybe 4 or 5, and then I've made some additional payments in addition to the $1,700. And she said, as long as I stick to the plan, then I'm fine. I have no other conditions other than to make payments.
Okay, so with her permission, you can skip
Yes,
payments. That's the way it works. Okay. Okay, I believe those are all the questions I have. Thank you.
Thank you.
Mr. Lee, any redirect?
I believe I do not.
At this point, I'd ask if the board members have any questions of the witness.
This is Joe Cleveland. Have you had any contact with Ron Park, Royal Capitan, or Capro Investments?
I have not. No, sir.
Have you been employed in real estate since you pled guilty?
No, sir.
Do you accept responsibility for what you did?
Absolutely.
Have you had any prior disciplinary imposed upon you as an attorney?
I had a private reprimand, but other than that, no.
What was the private reprimand about?
That was a client that I had. That was a litigation case. We initially won the case via default judgment. That was in Williamson County. The case was reinstated after the defendant filed a motion for new trial. Shortly after that time, my client had some arguments with me, and I told him that I was not going to continue as his attorney. And so what ended up happening at that point is I told him that he needed to find another attorney. Well, at that point, we were at the 16 or 18-month time frame in which Williamson County requires that everything be DWOPed if it hasn't gone to trial. And so there was because of the length of that case being reinstated, there was a need for some action there. And I told him that I wasn't going to take the action, but what I would do is I would give him a copy of the documents that I had drafted for him prior to our disagreement. And I did that. I gave it to him. He didn't take any action. He didn't hire another attorney. I withdrew. And so he filed a grievance against me.
This is Nancy Stone. I have a question, a couple of questions. Approximately how much of the $177,800 that you agreed to pay in restitution has been paid?
It's hard for me to give an exact number because they add probation fees and they add some other costs to that. But I want to say that I've paid in total approximately 33 or 36,000.
If I may, I hate to interrupt, but I did check with the probation officer and was told that he'd paid $52,000 in restitution.
And I have a follow-up question to that too. You referred to the plan, and under the current plan that you're making payments, when will the $177,800 restitution have been paid in full?
It has to be paid within that 10-year frame. That hasn't changed. So at some point, I'm going to have to catch up.
Thank you. No further questions.
Thank you.
I have a question, Mr. Rios. This is Kelly Henson. Of the $177,000 in restitution, is some portion of that the loan that you took out that had to be repaid, or is that all misapplied funds?
No. About 140,000, I believe, by my calculation, was the loan. The rest of it was the attorney's fees that were incurred by Capro's attorney in the underlying case. And I don't know if there's any funds for payments that were not handled properly, et cetera. But when they told me 177,000, that sounded very fair to me.
Okay, thank you. I don't have any other questions.
Thank you.
This is David Gonzalez. Mr. Rios, can you help me understand if that amount was discharged in bankruptcy? I'm not a bankruptcy lawyer, but I'm just having, and you've talked about what you and your attorney had done. Was that not a defense to repayment of restitution or something that would bar a criminal prosecution?
You know, we talked about that. I've done some bankruptcy work, maybe 5 cases in my career. I thought that it might be, and apparently it's not. And again, the issue was not so much as the repayment of that money at the criminal case. That was not the issue that I thought was, you know, the most daunting hurdle, let's say. I thought it was the fact that if there was any kind of recklessness that was found on how I handled remittances, then the amount really didn't matter. That's what I understood.
Okay, well, can you help? Thank you, because I kept thinking that as a loan amount, because you said you had borrowed some money for some property with some family. Did your family member that you had borrowed that money with, do you know if criminal charges were filed against them at all?
No, that money was paid back, and I guess I should have been more clear. So I made several loans over that time frame. So the 2 property loans I talked about, those had been paid back. There's no issue there. That's not even a concern. I just wanted to make sure that I talked about the scope. The vehicle loan that I talked about is paid back. The loans that remained were the personal loans. And so over that period from 2004 through 2007, a 3-year period, I borrowed approximately, I would say, is about $80,000 or $90,000. And so with interest, and because that's, again, at 15% interest, that adds up pretty quickly. And then with attorney's fees tacked onto that, it was a large amount of money.
When you talk about the remittances, were you in control of Capro's bank account?
No, I was in control of a separate bank account where, so here's the issue. When a borrower, let's say a borrower that had borrowed $100,000 and was making a $12,000 a month or $1,200 a month interest only payment, they would go and they would make a payment at Wells Fargo Bank at a joint account that I had with Ron Park. And so that money was deposited directly so that I wouldn't have to, and nobody else, I guess, would have to go and chase down a borrower that hadn't made a payment. So they would make deposits directly in. Ron didn't want there to be any kind of mail payments. I don't know if you can still hear me. It kind of froze up.
I can hear you. Can you hear me?
Okay. Did that? Yeah, I can hear you now. Go ahead.
So was one of the allegations that you had taken your commissions out of that remittance account?
Correct.
And that was an element of the recklessness or of a breach of fiduciary duty?
Yeah, exactly. And so that could be reckless. And then the other part that could be reckless was, like I said, if the payment had been made, for example, today is the 30th of April, and I wouldn't remit the payment out of that account into Capro's own account for a week or 2, then that could be seen as something that is reckless. And so, you know, I didn't want to take a chance with what I understand reckless to be something that could keep me from practicing.
Thank you, Mr. Rios. Does anyone have any other questions from the board? Hearing none, Mr. Lee, do you have any redirect?
Thought I did, and I should have written it down. I'll pass the witness.
Mr. Berry? Mr. Berry, we can't hear you. I'm so sorry.
I'm sorry. I had muted myself. I apologize. Regarding the prior judgment, Mr. Rios, you stated that you'd withdrawn from the representation. Isn't that true that the withdrawal was only about a week before the statute of limitations ran in that case?
That is correct. There was a deadline coming up, correct?
Thank you. That's all I have.
Actually, David, I do have one question for the witness. Hi, Mr. Rios, it's Jessica Barger. Can you explain a little bit the construction companies like that you own, how involved, and are commercial real estate, or what are they? Is it residential real estate, or what are they? A little bit more about your construction companies that you've been doing.
So what we do is welding. So for example, the tarpon, what that does is if a contractor calls us and says, hey, we need benches, for example, benches at the soccer stadium, the new soccer stadium. And then the commercial plumbing company, what we do, I'm actually in the office right now. Whenever somebody is building a building or a house, we do the plumbing prior to construction. And if there's service needed, our plumbers do service work.
Okay, got it. Thank you.
Thank you.
Does any party or any member of the board have any further questions for Mr. Rios? Hearing none, Mr. Lee, you may call your next witness.
I would call Attorney Stephen Tolan.
Good morning, Mr. Tolan.
Hi, good morning.
Let me swear you in.
Yes,
Would you please raise your right hand? Do you solemnly swear or affirm that under penalty of perjury that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Lee, you may proceed.
Hello, Mr. Tolan. Would you state your name for the record, sir?
Hi, good morning. My name is, full name is John Stephen Tolan. I go by Steve Tolan, T-O-L-A-N-D, and I'm an attorney here in Austin, Texas.
When were you licensed as an attorney?
So I was licensed in May of 2001.
Just for background, what undergraduate college did you attend?
So I attended Tulane University and then Mississippi College for a master's degree, and then went to law school at St. Mary's in San Antonio.
What year did you graduate from law school?
2000, to think about that.
And were you admitted shortly thereafter?
A little bit after, yes. I did some stuff with my family and then was admitted in May of 2001.
Are you licensed or admitted in any other states or jurisdictions or by any governmental agencies that require admission for a lawyer to appear?
So not admitted in any other states, nor have I sought that type of admission. I'm licensed and admitted in 3 of the 4 United States districts. I practice quite a bit in the Western District and the Southern Districts of Texas and federal court, and then some in the Northern District. And then I have pro hoc vice and several cases in other federal districts, like in the Northern District of California, North Carolina, Northern District of Oklahoma. And so I'm not technically licensed there, but I did pass some background approval and have cases actively there right now.
I assume you've never been disciplined as an attorney. Is that correct?
No, I have not. That is correct. And no, I have not.
Okay. What areas of law do you practice?
Probably 95 to 98% of my area of expertise, or I shouldn't say that technically, but is criminal law. So I practice in criminal law.
And how did you become acquainted with Jerry Rios?
So I was trying to think about that. I think 2 different ways. I'm a national board member for St. Mary's Law Alumni, and I think somebody had recommended Jerry that way. And then I think an attorney as well had recommended that Jerry talk to me. And so that I think it's kind of the combination of those 2 things.
So you were acquainted with him before you represented him?
No, I was not. I was acquainted with lawyers who know him and spoke highly of him, but I personally had not met him until I believe the 1st or 2nd week of September 2014, somewhere around there. And I know it was September of 2014.
Before we get started in the facts, just for the record, you've seen exhibits A and B, proposed respondents exhibits A and B.
So I'm following the rules based on the Zoom correspondence I had received. And so the only documents I have in front of me or anything I think are exhibits that kind of pre-marked, but since I was in a waiting room, I'm not exactly sure. So if you could just specifically tell me kind of what those are.
Exhibit A is a transcript of a plea hearing in state of
Yes.
Texas, and Exhibit B is the transcript of a sentencing hearing.
Yes, sir. So I do have in front of me the transcripts that I had obtained. Exhibit A is the plea transcript, or what we call the plea colloquy, and it's just the reporter's transcript of that hearing. And then likewise, I have the sentencing transcript as well.
Then you're the one who obtained those, and those are certified records?
Yes, they are. They are certified, and I personally obtained those since I was the attorney on that case.
Then you provided them to me,
Yes, sir, I did.
and I've in turn tendered them as potential exhibits, correct?
Yes, yes, sir.
Well, we would move to admit exhibits A and B, respondents A and B at this time. Mr. Gonzalez?
Any objections to respondents exhibits A?
No objections.
Respondents exhibits A and B are admitted.
Now, from all of the exhibits admitted, and I also provided you the bar's proposed exhibits 1 through 8, and since you weren't on the call, you don't know it, but they're all admitted. So you may also
Yes, sir.
examine those if you wish.
And I do, just for clarification of the record, those are the only paper documents I have. So those exhibits that, as you point out, are now admitted from petitioner, and then our responses exhibits A and B that we just admitted.
From the exhibits admitted, or from your personal knowledge, would you agree with me that approximately 3 years elapsed between the time of the filing of the indictment in Mr. Rios's case and the entry of a plea in his case? Is that correct?
Yes, sir. That's pretty correct.
At what point post-indictment did you enter the case as Mr. Rios's lawyer?
You know what? I apologize. I'm not exactly sure how far after the indictment. The case had a lot of history to it from bankruptcy court and things like that. So I'm not exactly sure, but I entered technically. I was looking at when I filed a notice of appearance and when it was signed off by Judge Aritia, but would have been around the 3rd week of September 2015. So I think it was about, or it might have been September, I'm sorry, 2014, around September 17th, somewhere in there, I think.
So you became involved in this matter shortly after the indictment was, what do they do? Hand them up, hand them down?
That's a great question. I guess you could technically say hand down the indictment, sure. But yes, but very shortly thereafter, because I kind of had a lot more knowledge about it than the initial assigned assistant district attorney. I think Pat McNallis at the time was that gentleman. And so, I was kind of bringing them up to speed because I had all copies of the bankruptcy records and pleadings and a lot of the civil stuff. And so I was kind of educating the initial assistant district attorney on kind of the way I kind of saw things.
Now, you mentioned the civil case and the bankruptcy case. They've been testified to by Mr. Rios. Let me ask you, were you involved in either representing him directly or indirectly or assisting him in either of those two cases when they were active?
No, sir. I only became aware of them after Mr. Rios hired me, right there in September, after he'd been indicted here in Travis County.
Okay. I assume that after he hired you, you undertook some investigation of the facts underlying the charges. Is that correct?
Yes, sir, it is.
How extensive was that investigation? Or what did you investigate and what did you learn?
I would say it was very thorough because there was a massive amount of financial records that consisted of routine spreadsheets. And so these spreadsheets were the manner and means by which I believe that Mr. Park and Mr. Capitan at Blue Wave or Capro Investments, and then Jerry, who worked with them for them, how they communicated about borrowers when they were paying, how they were doing on their loans. And then based on that, that's how Jerry would earn his paycheck. And so there was a lot of those records. And I wanted to focus on those to make sure it was clear that no theft was alleged, no theft had occurred. This is strictly an issue about responsibilities, boundaries with fiduciary, in a fiduciary capacity. So we spent a lot of time focusing on those. And then I spent a lot of time looking at the bankruptcy pleadings because I found it strange that this was now a criminal case and not a civil matter, given the pleadings, assertions, verifications made by Mr. Park and Mr. Capitan, as I recall, and then the receiver and the trustee and the judge ultimately discharging that debt. So we spent a lot of time focusing on those two principal areas, which were quite voluminous.
Would you agree with me that in the indictment and then later the amended indictment, Mr. Rios is accused of either intentional, knowing, or reckless misapplication of fiduciary property?
Correct. So in this particular charge, the 3245, it's those three elements, are all there. So you can intentionally do it, knowingly do it, or recklessly do it. And we can explain what do it means, technically in that, but that's correct. Those are the three requisite mens rea elements there, or mental states. Yeah.
Well, let me kind of jump ahead and then we'll come back to the investigation and the negotiations. But did you conclude? Well, I know you can't, none of us can give probabilities and trial outcomes, but did you have an opinion as to the likelihood of Mr. Rios being convicted of intentional misapplication of fiduciary property?
We felt very strongly that based on the government's, based on our discussions, without getting into hearsay, that everyone agreed it wasn't intentional. No one was alleging theft. No one had ever filed any pleadings in bankruptcy court about that. That assertion had never been made. So intentional was not an issue that anyone spent any time worried about. Obviously, there are risks if you go to trial, but that was something that I would never take a prosecutor's word that I will never argue for, because the statute does allow for that. And so a jury can find that finding of intentionality, even if the prosecutor doesn't argue for that. And so, but to answer your question directly, no one believed intentionality was at issue here. It seemed like, how can we pay this money back? It was really what a lot of the focus was on.
What about the mens rea of knowingly? Were you particularly concerned that the facts and evidence would support a knowing finding?
Well, no, we weren't, because again, the issue was that Jerry was given this money. Most of it was he loaned the money, or he was advanced commissions on his paycheck while he drives back and continues law school. And so if he had known that, not following a different procedure to put that money in a different place and then documenting it better about how he received payment by agreement from Mr. Park and Mr. Capitan, clearly he would have done that. I mean, any common sense person would have done that. And I know he would have done that. So no, we weren't concerned about that. If he had known that clearly was going to be such a violation of his fiduciary responsibilities under 3245, he probably wouldn't have done that either. So we weren't worried about that either.
So was your concern essentially focused on the reckless element?
Yes, it was. And there's a couple different reasons that went into that analysis of concern, but yes.
Would you care to, will you share those with this tribunal?
Yes, sir. I think those are important. So really the issue was the risk of substantial loss. So under this particular statute, the government doesn't need to show, nor does an aggrieved party need to show that there's a real possibility, a substantial probability or clear and convincing or, a preponderance of the evidence, or more likely than not, based on this economic chart about what a reasonable, prudent investor, that RPI standard, none of that really applies in the penal code definition of substantial risk of loss. It just says a real possibility of loss. And so just by definition, that the market they were in already, these high risk investments before the mortgage crisis happened, it was already risky enough. And so, I think anytime when a borrower pays money and then, Mr. Park gives permission for Jerry to do something, that's risky there, not documenting that stuff. That's all the government would have to show. And so that was always a concern, that is reckless by definition. And Jerry was always willing to accept responsibility for that. And that was always the issue. We accept responsibility for that part. How can we pay this back?
Would there have been a potential to simply, if he could have raised the money, pay it back and have the charges dismissed?
Absolutely. Absolutely.
How would you characterize your level of interactions with the Travis County District Attorney's Office during the period you were either investigating or negotiating with or dealing with their investigation of the facts of this case?
Well, their investigation, in my opinion, in large part consisted of documents we provided as well that were similar or exactly the same as the documents that they had received from Mr. Park and Mr. Capitan. That is these spreadsheets and the things I was talking to you about, and then the bankruptcy pleadings and all the documents in that. And so I would say it was collaborative is the best way to describe it. It was always, you have to keep in mind that it's a second-degree felony based on the financial loss table or calculation, just like federal sentencing guidelines, the same. And so if this amount of loss had been $2,500 or less, it's a Class A misdemeanor. Everything above it's a felony. So really the degree of felony is based solely, I shouldn't say primarily, only on the financial loss to the alleged victims here. And so that's what we focused on. So I'd say it was collaborative for those reasons.
Was Mr. Rios cooperative? Was he forthcoming in his dealings with you as his lawyer?
Yes, and we met with an investigator for the Travis County District Attorney's Office. We met in, then they had what they called their public integrity unit. So it's a separate building. We met up there with the prosecutor, a new prosecutor assigned to that case at that time, and their investigator, and we went through all the documents together. And so I would say he was very forthright in that regard.
And did you confer with Mr. Rios and indicate to him that by the way, there's been some discussion of his restitution being $177,000. Is that correct? What was the tender of 10,000 or 7, whatever it was, prior to the entry of the sentencing? What was that money for?
So that is, essentially you would just call it almost a good faith payment. I mean, the idea was if you could have gotten that money down to $149,999, this charge would have been a third degree. Because it's over 150,000, it's a second degree. The goal is just to get a head start, start paying off this amount. I mean, he was technically sued for $600,000. I'm not exactly sure how Mr. Park and Mr. Capitan came up with that number initially, but when we went through everything, the number that everyone agreed upon was short of $200,000, about 185,000, somewhere in there. And so this was just a reflection of trying to get a head start, because again, he probably end his probation earlier if you can pay that amount faster. It's a deferred community supervision probation, with the real onus being just the ability to pay that money back. So you pay it back faster by practicing law, then probably get off probation earlier. So it's really just a reflection of getting a head start.
They brought up practicing law. How did that figure into the negotiations, Mr. Rios's ability to practice law?
It was always the goal of all stated parties. And I mean, the assigned district attorney at that time, the one before that as well, with the judge, with probation, for him to be able to practice law. You'll note on one of the exhibits, I think, that the board provided was that the conditions of supervision, and you'll see at the very end, I think number 32 or 33, somewhere in there, it clearly states no real estate, don't practice in real estate, but it doesn't say anything about precluding him from practicing law. And then in our sentencing colloquy, we had discussed that off the record with Judge Uritia, but that's also mentioned on the record about, no real estate transactions, but you can practice real estate law. And it was pretty much agreed with. I mean, I could speak for St. Mary's debt, unfortunately, to pay back your law school debt and all your other obligations, he's going to have to be able to practice law and pay this money back. So that was always the intended goal of our negotiations.
When you talk about the record, are you referring to Exhibit B on page 5, where Mr. Rios directly says to the judge, I have a question just to clarify, I can handle real estate litigation, I assume that's okay? And the court says, yeah, that's fine. Is that what you're referring to?
Yes, specifically it begins with line 15 on page 5 of the sentencing transcript. And I could just affirm, under oath that we had those discussions multiple times off the record as well. And that is typical, that a prosecutor and a defense lawyer will talk with the in-court probation officer to make sure that we're all clear, because the last thing you want to do is start a probation and then a few months later find out that there was a misunderstanding on what you're allowed to do and what you weren't allowed to do. And then you'd have to come back to court. And so everyone was very clear about that.
What can you tell the board, tell us, what led to this mutual belief that Mr. Rios could practice law while on probation for reckless misapplication of fiduciary property?
Well, I think first and foremost that the government wasn't interested in going after him for that. They were wanting him to practice law. No one was fearful that he was stealing from clients or doing anything disingenuous like that. We thought that misapplication with a reckless standard would allow him to still be able to practice law. And I think all parties thought that. And the government also kind of made an assertion about, I've talked to the board, that's not going to be a problem, something along those lines. And so we didn't really have a lot of other options, to be honest with you. There's not a lot of other options. Misapplication can go all the way down to a Class B misdemeanor. Theft is certainly not an option. That's a moral turpitude crime. And that didn't fit the facts here either. I mean, that's not fair to make someone who plead to something where they're alleged to have stolen something. And so unfortunately, there just isn't a lot of wiggle room for something like this. But
you and I have conferred some, and I've indicated to you, I've shown you in the BAR Act, Texas Rules of Disciplinary Procedure, where even misdemeanor reckless misapplication of money or other property supports a compulsory discipline finding.
That's right.
Any idea? I mean, did you consult with anyone knowledgeable of the state bar rules and procedures prior to the entry of the plea?
Well, we did. I mean, I did.
I'm going to object. This is hearsay again.
I haven't asked him what was, I'm sorry, Your Honor.
It's okay. The objection is to the question, did you speak with anybody about this? Was that the question, Mr. Lee?
Prior to, yes, the entry of the plea, did you consult with anyone who is claimed to be knowledgeable of state bar rules and procedures?
The objection is overruled to that question.
We did. I mean, I did research on this issue, but I didn't get a professional opinion letter or anything like that.
Okay. Now, do you believe now, with hindsight, now seeing where we are, that if it had been pointed out to you that even a misdemeanor for misapplication, even under the lowest possible standard, reckless, could support this cause of action, were there other options for Mr. Rios that were not explored?
No, there weren't other options really available except going to trial. I mean, that would be the only other option.
There's not a lesser included offense? And by that, I mean, people maybe get picked up for DWI, but can plead to public intoxication. Was there a lesser included or something that would fit the facts that did not involve misapplication or theft?
No, sir. There's unfortunately not.
Well, if you can, again, without getting into hearsay, how did you analyze the pros and cons of Mr. Rios accepting a plea in this case, as opposed to going to trial?
Well, the biggest risk is if you're reckless, it's a pretty easy standard to show that you're reckless as a fiduciary, because first and foremost, it's clear that in his role as an employee and acting in, I guess you could call him an agent, with Capro Investments or Blue Wave Capital, that he had a fiduciary. His responsibility was, and during that whole time of employee, was as a fiduciary. So that's the first level of inquiry: is he a fiduciary? And the answer was yes. And then as a fiduciary, he doesn't matter if Mr. Park gives him permission, because the borrower who gives the money to Mr. Rios, even if Mr. Rios says, "Hey, I'm just documenting borrower A paid this," and Mr. Park says, "Okay, well, go ahead and take out X% for your payment there and go back to San Antonio, see you next weekend," or whatever. That doesn't matter, because the borrower still has, I guess I would call it standing, although the criminal code of procedure doesn't require that finding like that. But the borrower can still say, well, that's risky. I don't like that. I don't like that's a substantial risk that's not going to get credited to my account. So none of those borrowers came back and made claims of theft or anything like that. But but that is an easy standard to meet. And so we focused a lot of our inquiry on that. I guess you could almost call it sloppy. It's more than just sloppy bookkeeping. Is that Jerry accepted responsibility for that. He recognized as a fiduciary, and these are actions that occurred before he was a lawyer. But nonetheless, he accepted full responsibility for that. And so that was always to me a risk. That, and same with Mr. Rios, where he gave me, gave me instructions on he'd like to accept responsibility for that because he felt it was risky to go to trial. So that's pretty much why we did that.
Mr. Lee, can you pause for 1 second? There was a request from the board to take a 5-minute break. I know it always takes longer on Zoom regarding our announcements, but I'd like to be able to check in with the other litigants too and just let them know where we're at. So if it's possible, can we come back and is 11:15 too long? Is 11:10 too soon? What do the folks? We can go off the record.
May I attempt to contact the third witness and let him know where we stand in the proceedings?
Let's do that. Let's come back at 11:15. We'll be in recess until 11:15.
Okay, thank you.
Thank you.